Hello, this is Matt on the Moon Family Sedan channel. I have the latest for you in this latest Moon Family Sedan room temperature jam from attorney Jeremy Hogan and attorney John Deaton on the latest developments in the Coinbase and SEC lawsuit. Specifically, Coinbase, they're going to seek to have this whole thing dismissed, but it's interesting, especially for us here in the XRP community, because Coinbase is using Ripple's legal arguments to make points, and also they are doing nothing to remove XRP from the rear wheels of the bus that drove over it when Coinbase delisted it about 2.5 years ago. And although I still don't blame them, they were put in a particular position, I can't help but notice the way that they're treating things differently now. So maybe it's just a case of a Coinbase formerly being a bit linguini-spined and now having developed something of a backbone. Maybe that's it. Though I'll still hazard a guess that it perhaps has something to do with the fact that 2.5 years ago, Coinbase was seeking approval from the SEC to launch their IPO. And if that means, the sacrificing XRP, running over with the little bus, well, so be it. That's what I'm thinking might have played a bit of a part in this. So anyway, I'm going to share with you the latest perspective from the attorneys, but before recording any further, I do want to be clear, I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so here you have a tweet from Paul Graywall, who is Coinbase's chief legal officer, and he tweeted out the following. Today, Coinbase filed our answer and notice of intent to file a motion to dismiss the SEC case against us. You can read our response for yourself. Our arguments speak for themselves. And he filed this late last night, very late. Just at my time zone, it's Central Standard Time. It was at 11:20 p.m., so pretty late last night. And this big bad boy is 177 pages. Now, here's what attorney Jeremy Hogan had to say. He wrote, Coinbase filed its 177-page response to the SEC lawsuit. What jumped out to me is how Coinbase uses information/experience from the Ripple case, see the Hinman email reference below, and also throws in new stuff, the major questions doctrine. Yeah, so I'll pull up the screen grabs he has from this in case you want to read them. I'm not going to take the time to read through it. I don't think it's necessary to make the points from the attorneys. But I will note also that I'm going to circle back to the major questions doctrine because attorney John Deaton had something to say about that, and it's highly consequential. And why is it highly consequential? Because it's a new precedent that was set by the Supreme Court just last year. Specifically having to do with the case, EPA case. So, and I've talked about it on the channel before, but in case you aren't aware of it or you need a refresher, don't worry. I'm going to explain exactly what that is and then give attorney Deaton's perspective on that. Now, attorney Bill Morgan, he retweeted that from attorney Hogan. He wrote the following. Of course, the Coinbase uses helpful evidence from the Ripple case while it continues to halt secondary market trading of XRP on its exchange. It, of course, argues that secondary market trading of any token, apparently except XRP, fits not a single prong of the Howey test. And so, yeah, not surprising to see that the SEC, to this point, certainly not been willing to cede any ground as it pertains to prongs applying to any other cryptocurrency that it holds. And although technically it didn't cede ground, they didn't articulate, okay, yeah, you're right about XRP. It did satisfy those prongs of the Howey test. No, they didn't do that, but by removing it from the exchange, I mean, to acquiesce like that, it's like, it's not a good look if you want to argue that you did the right thing listing it in the first place. So I've always been a bit skeptical of that, and maybe still, I do think this is the most probable thing. If you're talking about safety of your company, especially at that particular moment in time, removing XRP might have been the most prudent thing that you could do. But I still admire, firms like Uphold, for example, which refused to delist XRP at the time. They still list it today. It's like, no, this is bogus nonsense. And so I admire that further. But first and foremost, I blame the SEC. And if you want to blame Coinbase after that, I get it. I understand. Everybody's entitled to their opinion. That's fine. But I hope we're all at least at the bare minimum, blaming the SEC first. Just saying here. Then there was also this from attorney Bill Morgan. He wrote, Coinbase D9 the allegation directed at the third prong of Howey in the part of the complaint in which it alleged Cardano is a digital asset security. No pause in Cardano trading on the Coinbase exchange. Different and inconsistent treatment of XRP where Coinbase halted trade. Yeah, totally fair critique. And I think that I see why they did it. They could have been a bit more spineless back then, like I said at the outset of the video. That mixed with the fact that they were going for the IPO. Like, sacrificial lamb. It's just XRP, no problem. Just run over the bus. No big problem. It's just a little bitch-ass XRP. That's probably, they're probably thinking along those lines. But here's the screen grab that attorney Morgan shared, which reads as follows. And so the top part is what came from the SEC. The information publicly disseminated by Cardano, IOHK, and Emergo, including since the initial sales of Cardano, have led Cardano holders, including those who purchased Cardano since May 2021, reasonably to view Cardano as an investment in and to expect profit from the Cardano Foundation's, IOHK's, and Emergo's efforts to grow the Cardano's platform, which, in turn, would increase the demand for and the value of Cardano. That's what the SEC wrote. And in response to that, Coinbase responded with one word, denied. So where was that with XRP, though? And I understand it wasn't literally the same situation, but who cares? I get it. So SEC filed a complaint specifically against Ripple. And in this case, the SEC has not actually sued Charles Hoskinson or anybody developing on top of the Cardano blockchain. I understand that. Does it functionally matter, though? You know, I've asked that question many times. I don't see how it matters. Like, some point is, yeah, but look, here's the distinction. Look, see, it's different. There's that. And I'm like, okay, yeah, I'm aware. Why does it matter? Is the asset a security or not? Because you know what they're arguing in the SEC v. Ripple case. Bunch of bogus nonsense. And so I get the frustration. I'm just saying, I'm highlighting it. I still don't blame Coinbase for doing what they did in the first place, but I have to acknowledge the disparity here. And I feel obliged to speculate as to why. And I've done that twice now in this video. Then there's this from attorney Jeremy Hogan. He says, the main problem Coinbase faces in its SEC lawsuit is that it has to essentially defend the non-security status of numerous tokens. Here you see that when confronted with a statement by Polygon, Coinbase can only respond, it says what it says. Fighting from a weak position. So what's he talking about here? Well, here's an assertion. So the top part where I'm circling, for those of you looking at the screen, this is what the SEC wrote. It reads as follows. This is a claim that the SEC is making, and then at the bottom of the screen is Coinbase's response here. And they're highlighting a tweet. That's what the SEC is doing here. So the SEC wrote, Polygon has explicitly encouraged Polygon purchasers to view Polygon as an investment in other ways. For example, in a February 5th, 2021 tweet, 14 months after Polygon's single biggest price drop, Malwal compared, so that's Sandeep Malwal, and I don't pretend to know a ton about, let me just pause right here. I don't know a ton about Polygon. I don't own it. And so that must be a crucial figure in that. And for those of you that own it, you're probably like, yeah, that is. I'm guessing. Otherwise, why would the SEC be highlighting this, obviously? So anyway, it's Sandeep Malwal. That's who they're referencing here. So again, it says, for example, in a February 5th, 2021 tweet, 14 months after Polygon's single biggest price drop, Malwal compared the token to a prize fighter that came back from defeat to become a champion. And then the tweet's on the screen for those of you that care to read it. I'm going to cruise on past that for the purposes of the video. I don't think it's necessary, but it's on the screen for those of you who want. Here is how Coinbase responded, and this is why attorney Hogan is noting that Coinbase is fighting, basically it's fighting from a weak position here. Because there's these assertions being made, but Coinbase didn't develop on top of Polygon. They're not a developer for Polygon. They're facilitating transactions in secondary markets for that particular cryptocurrency. That's what they're doing. That's it. Which we know, if you've been following the SEC v. Ripple case, you already know what that means. That ain't illegal, son. Of course, you can get a bad ruling from Judge Torres, but anyway. I don't think that's going to happen. We'll see. So anyway, here's how Coinbase responded. To the extent paragraph 159 purports to quote from or characterize public statements on Twitter, Coinbase respectfully directs the court to such statements for their complete and accurate contents. Coinbase denies the remaining allegations in paragraph 159. So there you go. It's basically Coinbase saying, well, here's the assertion from the SEC. Just go look at the source if you want the information, because it's not Coinbase's fight to fight. Or it's certainly, I mean, the SEC's trying to make it that way, but it sure as hell shouldn't be. It's pretty gross as far as I'm concerned. And now we get to what Attorney John Deaton had to say. But I want to set the table a little bit to make sure that y'all understand just a little bit about the major questions doctrine, because he does talk about this. Here's a piece from the American Bar Association from January 3rd of 2023, and it's titled, The Major Questions Doctrine Post-West Virginia v. EPA. So this is the case that led to this. Monumental case. I'm going to cover just the top part of this article. You don't need to go into great detail to understand the concept. You just need to understand the concept for the rest of this video to make sense. And so anyway, it reads as follows. By now, most have heard of the landmark Supreme Court case West Virginia v. EPA, 597 U.S. 2022, which, with Chief Justice Roberts delivering the court's opinion, clarified and cemented a new rule of statutory interpretation called the Major Questions Doctrine. This prudential doctrine requires that an agency point to a clear congressional authorization, and that's a quote, clear congressional authorization, when claiming authority from a statute. It is unclear at this time how frequently litigants and lower courts will employ this doctrine, which the Supreme Court devised to address a recurring problem of agency overreach, or whether the test will come up only in extraordinary cases. There you go. That's all you need to know for the purposes of this video. And this is also why I've said, again, this is the court, the Supreme Court, recognizing the problems pertaining to government overreach. Pick your agency. It's a serious issue. And that's why I keep saying, should the SEC v. Ripple case make it to the Supreme Court, which is certainly plausible, I hope it doesn't go that far, but it's certainly plausible. With the makeup of this Supreme Court, I don't think there's a snowball's chance in hell that the SEC gets what they want out of this. I really don't. And so if you look here at the Major Questions Doctrine, is the SEC pointing to clear congressional authorization to show that, is the SEC pointing to show that they should have some sort of rang over cryptocurrency exchanges, or even cryptocurrencies in general? Have they done that? Well, to the contrary, I'll just say this. Gary Gensler has previously articulated that he didn't have power over cryptocurrency exchanges to regulate them, and that was either in hearings leading up to him becoming the SEC chair, or it was right after he had become that. I can't remember, but I've seen the video. I've highlighted it on this channel. And so here, now, of course, now time has passed and flip-flopped, and yes, of course, we're in charge of that, because reasons. Okay, well, the Major Questions Doctrine states that you must show that there's clear congressional authorization to do all of the bitch-ass nonsense that you're doing, Gary Gensler. Where's the clear congressional authorization to show that you, Kim Jong-Gensler, are allowed to do the bitch-ass nonsense that you're doing? I'm not seeing it. Here's what Attorney Deaton had to say. I believe Coinbase's motion to dismiss, based on the Major Questions Doctrine, has real teeth. I'm not saying that it will be granted for sure. I'm just saying it's not your garden variety motion to dismiss where denial can be easily predicted. The motion has teeth because of the following. Number one, Congress is initiating legislation demonstrating its intent to legislate this major questions issue. So folks, Congress, although I think it's pretty clear, and Attorney Deaton has spoken about this many, many, many times, ad nauseum, you don't expect any sort of real guidance from Congress for probably years to come. So even though that's the case, we do know that Congress is moving on things pertaining to this exact issue. So would the judge, being aware of that Congress is in the process of figuring stuff out with this, understand that there is this a new precedent set by the Supreme Court, the Major Questions Doctrine? Would the judge look at that and think, well, SEC, can you point? Because there's this new precedent here. Can you point to why you clearly are in charge of this? You have the jurisdiction over this. Because it's something that's highly consequential, having to do with a substantial portion of the United States economy. And I understand, I say that, and I do believe that it's very relative. It's going to be way, way, way bigger. Just like if you're in the mid-90s talking about the promise of the internet and what that would mean for the United States economy. It's along those lines. Number 2, the Hinman emails discuss the regulatory gap and a greater confusion to the market. Exactly. So as far as the regulatory gap, I'll just note that the SEC acknowledged that the speech given by Hinman represented a regulatory gap. And noted that there would be greater confusion there. So with the judge being aware of this, now that the Hinman emails have come out, thank you SEC v. Ripple case, right? Could that be impactful? Could. The answer is yes, it could. Number 3, Gensler's original acknowledgement that there is no existing regulatory framework for digital assets. And I love that one. That's obviously true. But of course, everything's very, very clear, right? Number 4, the fact that there isn't a single case in history that has found a secondary sale of an investment contract to also be an investment contract. In fact, the one case that involved a secondary sale found that it wasn't. Well, how about that? Number 5, and actually, to bring the point home why that matters. Again, what is Coinbase doing? Are they developing on top of various blockchains? Are they even doing that? So no, so that's not a thing. What are they actually doing? The question, what are they doing? They're facilitating secondary market transactions. There is no precedent to state that doing so it represents some sort of investment contract. There is zero precedent. Number 5, there isn't a single case in history where the courts have found an investment contract when there exists no privity between the issuer/promoter and the buyer. So again, that's a similar concept. I mean, if you're purchasing from Coinbase, no privity between an issuer or a promoter, obviously. So how in the ever-loving hell would it make sense for the SEC to do what they're doing? Well, of course it doesn't. Number 6, the Supreme Court's decision in West Virginia versus EPA. And so that's what I was talking about, that case, before getting into Attorney Deaton's comments here. Because again, that's precedent set from the Supreme Court of the United States. That's some SCOTUS stuff, son. That's powerful stuff. And then Attorney Deaton says, it all depends on the predisposition of District Court Judge Catherine Polk Fila. Or Faya? I'm not sure how to say it. I haven't heard it pronounced, honestly. Failla. All I know about the judge is that she was appointed by President Obama from reading a Attorney James Murphy thread that's at Meta Lawman several weeks ago. That alone gives us no insight on how she will rule, but I see an interlocutory appeal coming in the near future. So that's where we're at. It'd be interesting. Can you imagine if this thing actually got dismissed? That seems almost unthinkable. But would it be, especially with the new precedent set in that EPA case? We'll see, folks. We'll see here. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.